Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about a recent draft data protection rule that has been unveiled by the Government of India and what are the concerns that has been raised around this particular rules by the expert. Let us try to examine this in more detail. Now, first of all, it is the Ministry of Electronics and Information Technology of the Government of India that has come up with the draft rules that is largely for the implementation of the act called as Digital Personal Data Protection Act that already was passed in the year 2023. And the Union government as of now is currently soliciting and looking at the feedback on this draft rule through a fiduciary framework that effectively precludes both public disclosure and the submission of the counter comments. So currently the bill is not taking, this particular rule for example is not taking the feedback from the public or the expert. Largely it is taking the feedback from what we can call as the data fiduciaries, that is a large social media companies or any company that is related to the processing and the use of data, personal data more precisely. Now the concern that has been raised about this, around this rule is related to the mandate called as data localization mandate. Now, what is data localization? In simple term, we can understand it is a kind of measures that is put into place that restrict the flow of the data within a jurisdiction's border. And in this case, jurisdiction can be India. So, how the data flow will happen within India to have a control over that is what we call as data localization. Now, in the this Protection of Data Act, before in 2023 we have discussed, it also has limited the personal data transfer, but those were only to the specific notified countries only. For example, how a data that is being transferred from India to US, that was the subject matter of DPDP Act. However, on the other hand, this particular rules also restrict the flow of data within the jurisdiction's internal border. Here also, in contrast of the DPDP Act, the rules propose the creation of a government appointed committee to define which classes of data cannot be exported from India. And here government has said that in this context, these rules will apply to significant data fiduciaries, SDF. Now, SDFs are largely designated by the government based on the volume and sensitivity of the personal data that they are processing. However, we have to understand that most of the large social media companies such as Facebook, Meta, YouTube, Google, all will be brought and be classified as a SDF because they are handling a large volume of the personal data of the Indian citizens. So basically, if this rule indeed kicks in, these companies will be affected and they will have to ensure that their data processing and control over the personal data is as per the data localization measures. Other thing is, if talk about the committee itself, a committee will, as far as the government is concerned, it will be a central body that will collaborate with the other ministries and sectoral regulators. Sectoral regulators means regulator from the telecom sector, regulator from the information technology sector, to ensure that the effective implementation of local data storage happen without disrupting the operations of the entire industry. Not only that, government has said that it will also be helpful because what is happening today, that we have multiple different government departments who are working independent of each other, who are working in silo. They're not collaborating and cooperating with each other, and each of these departments come up with their own data localization mandate. And that is why it becomes very difficult for any organization to adhere to these guidelines. So such kind of committee will be an apex committee, and that is why it will help prevent such kind of mandate from the local government departments. They will have to ensure, the companies will have to ensure that they follow a single mandate given by the central by this particular committee. Government plans to provide the industry with a 2-year timeline to establish the necessary systems for compliance. This is something that has been said by the Union Information Broadcasting Minister Ashwini Vaishnaw. That means the implementation, even if the rules are passed as implemented, it is not that it will be sudden in nature. There will be a significant, or we can say a large scale timeline of 2 years will be given so that companies can adjust their operations based on the guidelines. The other concern that has been raised about this bill is related to the executive outreach or overreach, because if you look at the section 36 of the Digital Personal Data Protection Act 2023, it clearly states that within the rule 22 of it, it empowers the union government through the designated authorized person to demand any information from a data fiduciary or data intermediary. Data fiduciary here refers to again any organization which is dealing with the personal data, and it is this organization that determines that how this personal data can be used and processed. So any kind of information from these data fiduciary or intermediaries can be sought by the government through any designated authorized person or agency. And when this can be done, it's not in all the cases, but only in those cases where government feels that not sharing of such information data can have a negative impact on the sovereignty, integrity or national security of India. Not only that, the rule 22 also states that if in such situations a data is being sought by the government from the fiduciary or intermediaries, the companies cannot disclose the kind of information that government has demanded from them. And this is because the belief that such kind of display of information or making such information public will again prejudicially affect the three things: the sovereignty, integrity and the security of the India. However, many experts argue that this is nothing but an example of surveillance state that the government tried to create or government is trying to create by executive outreach. Now, experts have cautioned that such sweeping discretionary power as the government can assign to any of the designated officers and agencies are susceptible to misuse, and that is not something that will happen for the first time. It has been seen in many cases in the past as well, because it enables surveillance or the suppression of dissent, especially many political parties who are in the power began to take advantage or began to take advantage of this kind of law, and they potentially target those people who are in the opposition. So that is what the experts argue, that it would compel the social media intermediaries to compromise end-to-end encryption of the messages as well. For example, if you have messaged on the WhatsApp to someone, and you might have seen the display that this message is end-to-end encrypted. What does it basically mean? It means that only the person to who you are sending the message or who is the intended recipient of the message is only able to read the message. Even the social media company and the platform of whichever company you are using will not be able to look at the messages, private messages. So this can also be threatened by this particular rule, and this is also the concern was raised last year also by the Meta on WhatsApp. As you know that WhatsApp messaging are end-to-end encrypted. Now let us try to understand about the end-to-end encryption. For example, in end-to-end encryption, what happens? If suppose Mary wants to send a message to the John, then Mary has written hello. Now as soon as she sent the message will be encrypted, and this encryption cannot be read by the server who has received the message, because when suppose you are sending the message from your mobile phone to some of your friend, first of all what happens, the mobile phone, from your mobile phone the message is sent to the WhatsApp server, and the WhatsApp server forward the message to the recipient. In this process, the server is not able to read the exact text of a message because it is encrypted, and then the recipient will read the message through his key, and that is where the decryption happens. So this kind of messaging or the transmission of information is called as end-to-end encryption. Now in this context also, earlier a group of experts on privacy has given their statement, and they also have said that those individuals who are subject to interception should be notified, but that is what the government has not allowed to do so, especially in the context of security, integrity, territorial integrity, sovereignty or the security of the country. Second, there is an ample evidence of interception orders being misused by the police department under political influence. As I told you that politicians can take advantage of this, especially those parties who are in the power. And there is a need of adequate checks and balances, which many experts argue seems to be missing from this particular rules. And adopting of safeguard akin to those under the IT Act 2000 to ensure that citizens are not left completely unaware that they might be surveilled or their information, their messages, their call records are being surveilled by the government. So for that matter, the individual should be given insight into it. Now the major criticism also arises from the fact that the experts argue that the rules that has been brought under this DPDP Act, it is inadequate for establishing a comprehensive data privacy framework. Data Protection Board must formulate robust regulations and standard operating procedures to bridge the gaps in the law. As we have talked before, that there are a lot of loopholes, a lot of gaps which is prone to misuse, which can be prone to misuse in the future. Government should consider submitting the rules to a parliamentary standing committee as well for the scrutiny purpose. That is other recommendations given by the expert committee, because it is believed that once the bill is sent or the rules are sent for the parliamentary standing committee, it will be able to accommodate a diverse viewpoint coming from the expert, coming from the public and any other stakeholders, and this inclusion of diverse perspective will make rule much more effective and much more acceptable in the public domain. Now, as far as the view of judiciary on this entire matter is concerned, the previously also courts in many of their judgments have stated that the government and the exemption that has been granted to the government under any act or bill should be interpreted as narrowly as possible. That means the problem here is the three matters: sovereignty, security, and integrity. Now, government can explain any act as threatening these three things of India. So there is a element of subjectivity that comes into picture, and many times whether those elements of subjectivity are valid ground or not for surveillance of any people or their messages, if that matter is referred to the court in the earlier cases have interpreted as narrowly. That means they have a very limited scope to which the government exemption can be applied. So whenever the government has overstepped such powers, the courts have intervened to safeguard the fundamental rights of the citizen. So same thing will happen in the future as well if the matter is referred to the court. So that is all about this particular video. I hope you got the idea of the rules that has come for the data protection in India and what is the concerns and the challenges in implementation of these rules and overall acceptance of this rule. Thank you very much.